So, let me get past this over here. The co-ownership really just means that there's more than one person who is either on the deed or has a vested interest in a particular piece of property. It can be residential, agricultural, commercial. Partition is a remedy that applies to all those types of real estate. Sometimes you have a situation where there are multiple owners, but they are not all on the deed. In that circumstance, you will find, we will allege what's called constructive trust. And that's a theory where the one person or the two people who are named on the deed are acting as trustees for the benefit of the other people who are not on the deed. Additionally, it can apply to a circumstance where you have incorrect ownership percentages as well, and that's another allegation that's commonly found in a partition dispute. So another unusual situation that partition can apply to is when you have an individual who's actually on the deed but doesn't even have a real ownership at all, is like a 0% owner. Functionally, somebody else is paying 100% of the mortgage, property, taxes, insurance. So in those circumstances, partition can also be a remedy. It's a little unusual, but we have encountered it. It's typically the same reason that people need to exit. This is perhaps they need to buy a house of their own, and it's looking like their credit is maxed out because they are entitled to this shared piece of property. That's common in a community purchase. So the situation I just described, where you might have one or two nominal individuals who are on title, but they're not actually responsible for paying the mortgage because either the church or the community group is paying the mortgage, that's a circumstance where the costs of ownership are not the reason that somebody needs to exit the co-ownership. So a partition itself is statutory. There's a section in the California Code of Civil Procedure that allows a co-owner to file this partition action, which is saying that they're ready to have the property be sold. There's no other solution between co-owners except for the sale of the property. So that's essentially what partition is. The preliminary issue is, who are the owners and what type of ownership do they have? If a co-ownership situation is actually in dispute, then you can expect to have a trial on those type of preliminary issues as well. Even if the ownership interests aren't just in dispute, for example, you've procured a lot book guarantee or a litigation guarantee where you have clear understanding of title. Each person owns 50% or 4 people own 25%, and there isn't a dispute as to who is on title and how much they own. You may still end up having to have a trial early on, which is an interlocutory procedure, and it's simply for the court to make a determination if we're eligible for the partition. So eligibility is pretty clear. There are really only two things that would prevent you from partitioning, and one is if you're married, because then this code section doesn't apply. They have family code procedures for that. The other one is if you've waived the right to partition, which you will typically see in co-op situation, other co-tenancy arrangements where people have it's common in San Francisco where they've bought a single piece of property and maybe there are 4 units inside, and they're all operating under a co-tenancy agreement. So those are circumstances where you'll see that they have agreed to waive the right of partition. Otherwise, it doesn't matter if you only own a small percentage of the property, you're still eligible to seek partition as a remedy. So there are 3 kinds of partition actions. One is partition in kind, and that is more common with property that's quite large, like rural property. If somebody has significant acreage and it's 2,000 square foot ranch or something like that, then a 2,000 acre ranch, then you can see that partition in kind may make sense because they might just need to sell off a disputed portion or a portion that has access or a portion with water. So that's partition in kind. There's another method when the parties are somewhat in agreement. So you can seek partition by appraisal. It has to be voluntary, though, in the sense that both sides, or if there are multiple sides, they all need to agree that they will do the partition by this method. And this could work in circumstances where one of the co-owners has expressed interest in buying out the property, but there's significant disagreement about the value of the property. So the final method, and the one that's most common, is partition by sale, because the property can't be divided in kind. This is going to be for your typical commercial buildings or your single-family residential properties. So frequently, I would say a higher percentage of our activity is always the partition by sale. That doesn't mean you wouldn't also get an appraisal. That's very common, that a co-owner would obtain an appraisal, or that the referee will obtain an appraisal. And we'll talk a little bit about the referee mechanics as we get going down these slides. So what are the reasons for partition? I've touched upon it a little bit in the sense that you will have a situation where somebody needs to exit this in effect, partnership. And so typically it's going to be disagreement over the use of the property, maybe the benefits accruing from the property, like the rents, or the rights to do things with the property, such as one party wants to rent it out and another party wants to keep it as a family vacation home. So when you start your partition, it's a state court lawsuit. We just file it in the county where the property is located. And what we see is that the parties haven't really put in writing anything. I mean, you might have a very serious exchange of emails about what to do about the property, but probably before acquiring the property, there wasn't a written ownership agreement about people's respective rights to the property and who was going to pay for what and how they were going to use it. So that's a common characteristic of what starts off the likelihood of a dispute and need for partition action. Often the property is held just as tenants in common, and you can see that either in an inheritance situation where it's deeded to multiple generations or to multiple siblings. Let's see, not sure about that slide, so we're going to skip that. So inheritance is probably the most common situation that I've seen, where second homes, investment properties, even the family home is just divided up between each relative equally. Now, in real life, not everybody is equitably treated. They don't treat each other equally. So even though their shares are equal, the use or benefits flowing from the property are not equally applied, and that's when partition is the right remedy. So similarly, we see situations where, especially during the boom of the fix and flip, you had a lot of investors in co-owning property, and so you might have someone supplying the sweat equity, somebody else doing more of the financial stake, possibly somebody else with the marketing capability to list and sell the investment property. So those are also common co-ownership situations on and how you become a co-owner. And the last way that we also saw, because we represent several private lenders, is that the lender had to take back the property at foreclosure sale, and there were multiple lenders on the note and deed of trust, and so they are forced into co-ownership at the conclusion of the foreclosure sale when it became REO. So those are the three most common ways that we see people become co-owners and likely would need a protection at some point in the future. So oftentimes when we talk about use, that's occupying the property, right? Typical dispute scenarios arise when you have one owner living in the property and excluding the other owner from the property, right? Or the other owner has another place to live and doesn't need to live in the inherited property. So that's one situation. Another one, it could be that everybody did agree that one of the co-owners could occupy the property. However, they're not maintaining the property, so the property is starting to fall into disrepair. And now you have a situation where maintenance costs are now starting to rise with this asset. So now this, what should be a positive or cash flowing asset, is now actually a cost burden for the co-owner. And another scenario that we saw after the subprime meltdown is that people wanted to exit because they needed relief from the mortgage. You know, maybe the note was about to adjust or something like that, or in general, this is a high fixed cost and the property is not cash flowing. Another reason that we see for partition is that maybe the original owner, before passing it on, was not maintaining the property. And so now, once the siblings or beneficiaries have acquired the property, there is just a huge up cost, maybe a roof, 5 figures, or other repairs that need to occur, foundation work, things like that. That can be a real burden for a co-owner, especially if they have a home of their own and they also have their own mortgage to service. So those are reasons that you need relief, and that's what the partition is supposed to provide. The last one, which can come up, is that geographically you may have a co-owner that is the closest to the asset, and they are the co-owner that is now tasked with much of the burden of traveling and managing that asset. And if they're not a licensee, they're probably not getting compensated for managing that asset. So this is another reason, usually tacked on to others, that people need relief and wish to sell the asset. So we talked a little bit about the mechanics. I start with a filing in the state court, but even before drafting the filing, I will obtain a title report, a product from the title insurance company that tells me who the vested owners are and what the situation is with the title. This is something that we also plead into the complaint as well, so that it's available and it can be shared amongst the co-owners. But typically that isn't the dispute. Most people tend to already know who's on title by the time they've come to you and there's a problem. Once the complaint is filed in state court, it should be filed in the civil division, and so it will follow the typical scheduling and judge assignment and case management schedule. The part that makes partition actions a little different is strategically, when you are the claimant or you're the plaintiff, you're looking at bringing on board a referee and the timing to do that if you think the parties aren't going to stipulate to an interlocutory judgment. So upon filing, the next step is usually to then assess, okay, can I get a stipulation from the other side for an interlocutory judgment saying that this property is going to be sold? And the reason being is the partition code is very straightforward. The dispute is not usually whether there should be a sale or there will be a sale. The remedy is clear. There's going to be a sale. So usually the disputes are over things like the accounting, or the process, or what to do about the listing for the property. That's typically where the disputes can arise. Now, occasionally you will find there's a dispute between co-owners because there's some belief on one party that they have the right to occupy it for longer, as if there's an implied waiver of the right to partition. And so in that circumstance, you might get a real fight on your hands as to the stipulation for interlocutory judgment that there will be no stip, and instead you're going to have a trial at that phase. to have the judge order the partition and appoint the referee. So as I was saying before, if the other side is getting the same amount of information and they are sharing it with their counsel may be advising them that, hey, there aren't a lot of defenses to partition, so it will cost a lot less money, and it's better if everyone has fewer attorney's fees. So we should stipulate to an interlocutory judgment and work on crafting something you can live with. So that's, I would say, more common. More than half the time, this is what's going on after the filing of the complaint. There are a lot of benefits here in the stipulation, because the parties can agree on a referee. They can agree on essentially decision-making rights. Do the parties say, hey, we obviously already decided we can't agree, so we're going to have the referee decide on everything, meaning they will engage the listing agent, or they will update the property and repair these things before selling, and do the owners take themselves out of the equation in crafting this stipulation? Or do they say, no, we want lots of rights, we want to talk to each other, we want to try and propose these people, we want to have a process that says the referee is the tiebreaker after one of us each gets a shot at doing something? So this is very custom, and it's unique to the parties, and this is where a lot of the work happens. So if, however, you aren't able to arrive at a stipulation, then you will have a hearing or a trial, or you can bring an MSJ on the right to partition. Again, this is more for the court to evaluate your eligibility for partition. So if you are a co-owner and you haven't waived the right to partition, you're eligible for this remedy. And so this is a fairly routine motion or routine offer of proof that you will make to the judge. The judge at this phase doesn't have to decide on things like the accounting or whether or not there are different percentages of ownership. They are really looking at the mechanics of getting you to the sale itself. So that's what's taken care of at this phase of the proceeding. Hopefully you have already looked into having a referee before you've filed the complaint and prepared a stipulation, because this is where I think the real meat of the partition action is. The referee has to be a trusted, neutral, somebody who really has the ability to work with the parties, make decisions, manage the asset, and it's often ideal if they are local, or if they are not themselves local, that they have a local network, handyman or whoever it is, in order to get this property sold for the plaintiff. So a lot of the legwork comes really early on in selecting the referee. Let's see if I have a slide for this. So the point being that the referee is going to be reporting to the court. The referee is going to be handling all of the vendors needed to complete the sale, and the referee should also be very familiar with what has to happen on the escrow side, because the disbursement of the funds is going to become a huge issue later on. Usually the referee is going to have to hold the funds in their own trust account, or else have an order beforehand designating who is holding the funds. And this level of responsibility, I mean, they really are, the referee probably would do more legwork than the attorneys themselves during the partition action. Often they are professional receivers, but they don't have to be. They can be very experienced realtors, local attorneys, or another related profession. They are appointed by the court, so they need to be familiar with court proceedings, have the ability to provide updates to the court, whether by engaging counsel of their own, or if they are an attorney, to update the court through pleadings and to update the parties as well. They're governed by the judicial code. They are a quasi-judicial party. the only person who's not really eligible to be a referee, in addition to the other criteria listed above, is that none of the co-owners can be a referee, even if they are otherwise qualified. Let's see. So the duties and powers of the referee can be pretty expansive. There's certainly statutory grounds, statutory authority that says what the referee can and can't do, whether or not they're personally liable, they're not. And your stipulation or the order that you end up with can provide what the powers of the referee will be. So if one party, one co-owner is extremely difficult and they will not be signing any documents, that means the referee has to be empowered to sign these instruments, such as the grant deed itself, or be empowered to sign the listing agreement. Additionally, the referee needs to be able to hire other professionals, either their own counsel or accounts and appraisers as well. So that's typically what you would see, the referee's sort of own early checklist of duties that they are going to go through. They may often need to update the property or make repairs to get it ready for sale, in which case they'll be working with maybe a general contractor or other licensed bonded professionals. So there's a lot that happens from the referee's perspective, and this is why I said that's really the heart of the partition, I think, is the referee, because they do all of the legwork. They have to really manage the emotions of the parties who are obviously not in agreement in the first place, or they wouldn't need a referee. And the more organized the referee is, the better they are at sort of scheduling, I would say. They're going to be in a good position then to address the needs of each party, because one of the hardest things I think a referee would have to do is, if there is a co-owner that's occupying the property, the referee is going to have to evict co-owner if the co-owner will not exit the property. So this becomes an extremely challenging portion of the referee's job, and so some referees might be very, say, distanced from it and seek court aid. They can go for a clarifying order in order to figure out, is this an ejectment situation, or is there some other remedy here? Oftentimes, they will try a more direct approach, which is to assist the exit of the co-owner because they're tasked with clearing the property. So if the property has years of accumulated items, all of that needs to be addressed anyway before staging the house for sale. So this time frame is important when the referee gets in there. They've been tasked by the court. Now there's an order appointing them, and they know they need to go in and get the property ready for sale. So there should be a flurry of activity, and the referee's fees, this is probably where they end up generating the bulk of their fees here. At this point, if co-owners are not agreeing, but they're seeing that the referee is really working hard and it's going to cost them a lot of money, sometimes this can be incentive for the parties to work something out, because oftentimes, especially in a family dispute, having an outside third party come in and dealing with family assets can be a little jarring, and in which case they may decide, okay, we would rather work amongst ourselves than defer everything to the referee. So then it becomes an issue of what powers have you reserved in the stipulation or are left in the order remaining to the co-owners, or is everything going to be driven by the referee, in which case it's too late for that type of situation, short of a formal settlement. So the sale of the property itself it can follow a fairly conventional route. The referee obviously has a duty to optimize the sale, and either that can be the amount of the sale price, or it can be, if dictated by the parties, and if the parties are in agreement, based on the speed of close, right? The referee, though, often is balancing those two factors, either time or money. So depending on the situations of the co-owners, whether or not one has the ability to advance repair costs or advance fees for painting and that kind of thing, this is what will drive some of the decision making for the referee on whether or not to list it right away or to do some of the work first before listing it. In a conventional format, the referee will often obtain a listing broker and have offers, and it will look like a fairly normal sale but still be subject to court approval. Additionally, the referee can sort of take the auction approach and say, all right, we're going to have an offer, and then at the confirmation hearing, other potential buyers can also show up and have an auction. And so in that format, often the judge will get involved, and they will issue bidding instructions, for example, increments and terms, whether or not there will be financing allowed or it's got to be an all-cash offer. So those types of restrictions start to become, I guess, communicated to the parties once it really looks like there's some interest in a buyer's on the buyer side or multiple offer situation. Okay, I'm going to go back one more slide here. So when it says closing escrow on court approval, one of the things I found that is also helpful is if the referee or counsel for one of the parties takes a form of order to the title companies early. And because the title company, the escrow officer will tell you what they need to be in the order, because oftentimes it's the referee signing the grant deed or money is going to the trustee's trust account. All of those things, I think, the escrow officer really needs a clear order on from the court. So it's better to get that early as opposed to go back serially to the court each time for each step of the way. The more experienced referee, the more they have their own approved language that they like to use, that they know has been successful in the past with escrow officers. Okay, so if you are now fast forwarding into the partition action and the property's been sold, you've closed escrow, there's hopefully a pot of money for people. This is where we start to see, I would say, another wave of potential conflict, because costs of the partition can include the attorney's fees. And by statute, the claimant, the plaintiff, can say, hey, I incurred these fees for the common benefit. We're 50-50 owners. I think the other co-owner should have to pay 50% of my attorney's fees, and I've spent X thousand dollars. Similarly, the referee's fees would also need to be accounted for during this phase of the litigation. And so all of this ends up being part of a counting with the referee and a motion for equitable apportionment from the plaintiff. So the judge has the discretion to look at it kind of in a lump sum, like in totality, i.e. attorney's fees plus the referee's fees, or they can break it apart. But either way, the code doesn't set the way that it's partitioned. It simply says that it's something that the court shall do, which is either pro rata or by other method. And so a few years back, there was a very contentious partition action between a number of siblings, and it was also a constructive trust situation. This is the Lynn case. So I think it was in 2012. So in the Lynn case, you had these siblings where the deed might say that they owned 85%, but actually mom and dad said, no, we expect that each of you are actually only owning a smaller fraction, and then each of them servicing a portion of the mortgage. So they actually had a very lengthy and prolonged litigation over the ownership percentages, and then each party had racked up very large attorney's fees. So one side had 80 grand, and another side had 103 grand in attorney's fees. And of course, each side said, well, I think the other side should pay their pro rata share of my attorney's fees. So when faced with that decision, the court looked at the equitable nature and whether or not those fees were really for the common benefit. And so what the court said was, owner A, who had the record ownership of 85%, but the actual ownership of 15%, your attorney's fees were not incurred for the common benefit. You were actually just trying to preserve your own interest and beyond what you actually own. So in that case, they denied her fee motion in its entirety. So she did not get any apportionment of the 80 grand she spent. And for the remaining siblings who each owned 15% of the property or something like that, the court said, yes, this is a common benefit situation. So of the $103,000, each co-owner paid their pro rata share of that party's attorney fees. The case didn't say how the referee's fees were treated, so I don't know ultimately what happened with that, but we've seen situations where the referee has had to expend significant energy in preparing the property for sale, and that it was caused by one of the co-owners, and in that case you saw that there was a disproportional allocation, meaning the apportionment was to approximate or somehow reflect the fact that one co-owner was causing most of the need for the referee's fees. And this happened fairly close in time to close of escrow, so there wasn't an undue delay, but it is a lot of work. A fee motion, even in a regular case, is a pretty comprehensive filing by the parties because there's a lot of scrutiny for each fee. And another issue that can arise here in a partition is the allegation of rents. This always comes up while one co-owner is living in the property and the excluded owner is saying, well, hey, why aren't I getting rents? Well, you're not getting rents because under tenancy and common law, each co-owner has an equal right to use the property, so they don't have to pay each other rent. However, there is a case on point with respect to what happens at the partition, and that one, again, it's equitable, but sometimes you can make a request for a rental offset. So in that case, the excluded co-owner is saying, I know the other co-owner doesn't owe me rent, but I think at time of sale, there should be some sort of accounting back and forth for the fact that it could have been rented out at the time and I didn't get that income. And similarly, the property occupant will say, I spent all this money on repairs, I improved the property, I did this, I maintained it. And so that's where the accounting becomes incredibly fact specific. And it can cause, I would say, like multiple briefing scenario, very likely. So let's see if, okay, well, so in the cost of sales scenario, the mortgage, the listing broker's commission, and that all the commissions will come off the top. And then the referee often first asks for a briefing from the parties, then makes their own recommendation, and then there's a hearing at court. And that's typically the process that we see. So that's what I meant about multiple briefing scenarios, because the referee may make a recommendation and you may end up challenging the recommendation. So that's why you would be maybe having a couple of rounds with the referee, and then the referee saying, all right, well, I've revised or I'm not going to revise my recommendation, and let's have our hearing now and go to court. So the parties will, by then, have already laid all their cards on the table and then put it before the judge at that stage. Okay, so that would conclude essentially the partition. You would have a judgment for partition. The partition would have occurred, the property would be sold, and the final step is the accounting, and the judge rules on the accounting, the funds are dispersed. And so the partition is a very finite and, I would say, directed type of litigation activity. Lots of cases tend to have a lot of uncertainty as to what will happen. But in a partition action, the uncertainty is not about whether or not the property will be sold. The uncertainty comes from how long it would take and what the accounting is going to shake out to be. So let's see if there are some questions. I see like a highlight of 5 things here. Let me just check. Okay, so I don't see on my chat list express questions, so I'm going to hit a couple of the special interests section here. A common question that I get is, what about the right to buy out the other co-owner? Sometimes you have a situation where one co-owner has significant funding available, and so they want to make an offer to buy it out. Well, the problem is, under the partition statute, you don't have a right to buy the property. You can participate in either the auction format or the actual sale proceeding, and your offer could be the highest offer and get approved anyway, but there is no guarantee of being able to buy the property from your co-owner. Similarly, you don't have an option or a right of first refusal. Now, that said, I think a unique issue in a partition is if it's a hotly contested litigation and you have a lis pendens there, I think that actually could chill the pricing for other outside buyers, meaning, anytime you see a situation where court approval is needed and you see, if you're a prospective buyer and you see, okay, well, I'm going to have to go through court approval, and then potentially my offer is subject to bidding, so I'm really this sort of starting point for bidding, that can be like unpleasant for some buyers, or present enough risk that you might actually be limiting your potential buyer pool, in which case I don't know if that is is a factor in lowering the value of the property, but in some ways it does delay the close of escrow, in which case some people need to get into their properties a little sooner than that. Maybe they're dealing with the school deadline, so you're kind of missing out on those types of buyers. So that's one specialty or special area of inquiry I see. Another situation that can come up in a slower market is you don't have very many offers, or the offers aren't all cash offers. So instead you have oops, I'll close that. Instead you have a situation where the only offer that's on the table, and the referee is inclined to recommend taking it, is seller carryback. Well, under that circumstance, the court could order that. And so what it does is it puts the co-owner in the position of being a lender. So I haven't encountered it personally, but I wouldn't be surprised. The more specialized the property, meaning if it's only suited for particular use, or let's say it's a big ranch, so really the pool of buyers is limited to people who could handle that particular type of property, I would see that scenario becoming more likely. Another situation you can see is that if one co-owner is really obstreperous or really fighting the partition, they may challenge the confirmation of the sale, or possibly they feel like not sufficient offers or it's the wrong price. They can also use this motion process in order to tell the judge that there wasn't sufficient marketing of the property, the pricing is too low, that the sale shouldn't be confirmed for those reasons. So, or that the referee failed to notify the public of this auction process, and therefore chilled the bidding in that manner. So those are situations that I can foresee happening in a very fractious property, maybe like commercial property where the values are very high and fluctuate a lot. I could see that happening. Okay, I do have some questions here. Let me see if this affects your screen or not. Oops. Okay, so one question, how are liens on the property satisfied? Well, they should come off the top because the escrow officer will be getting payoff demands. Can the court void or eliminate liens as to title being taken by the purchaser at sale? You know, this is a regular sale. It's not a foreclosure sale. So it doesn't wipe out junior liens or anything like that. I think it's, in that respect, the same as a conventional sale. Everybody needs to be paid off. And it needs to be sold free and clear or the buyer's lender won't close. Okay. I'm going to apologize here that, you know, there's this tiny little screen in the corner that I've seen some scrolling questions and I'm just trying to get to them. All right, so if the other side is willing to stipulate to an interlocutory judgment, why is there a need for the partition action in the first place? You know, sometimes people don't have enough information, and so what you see oftentimes is party A and B are trying to talk it out, and they can't agree on the listing agent, and they can't agree on when to sell because one party wants to time it, another party wants to wait for some event to occur, and so if one co-owner has decided the other one is, you know, being unreasonable or they really can't get some traction, their only remedy is to seek the partition. And at that point, it creates a scenario where party B may seek counsel, and a reputable real estate attorney will tell them, you know, there aren't a lot of defenses to a partition, meaning it is likely that it will be sold. So let's try and get involved in this process so we can negotiate things that work for you. And at that point, you'll start to see that there's a possibility of people putting in their preferences. Meaning, okay, well, I'm going to propose a listing agent I like, and the other side's going to propose one, and the referee's going to interview them both, and then either hire a third or one of the two. And those types of procedures can go in the stip, which, you know, I think there's a little bit of that element of, okay, well, now somebody's supervising. Now we have to go in front of a judge. Now there are third-party costs accruing, and sometimes that causes people to be more willing to participate in discussion when they realize, well, a sale's happening no matter what. So now the issue is, how much influence can I have in how that sale occurs? Okay, so another question. The co-owner has agreed to sell the house but has delayed cleaning out the house for over a year. What to do prior to partition? Well, so this is exactly the kind of scenario, you know, that referees often encounter because the parties couldn't resolve this prior to the filing of a partition. You know, I often read these long chains of sometimes handwritten letters, but other times emails between co-owners trying to work out a solution and trying to deal with grandma's china cabinet and who's going to get this and who's going to get that. And this is especially problematic in a family property where the assets are, or the personal property is, I would say, numerous and also difficult to value because maybe it has sentimental value just to the parties. So in those circumstances, we've actually had a judge recommend to the parties, and this is obviously taking place after the filing of the partition. We've had the judge recommend that people go in and tag the things they want, and everybody gets 5, and if they can't agree on the 5 that they want, then they're going back on the judge. So that took place in a fairly unusual context where the judge had a probate appointment, so the judge had been used to dealing with personal property disbursements for family members before. Sometimes people hire a third party to go in and deal with the cleaning out of the house. So again, you know, if the house is vacant, that presents other problems and security risk as well and insurance issues. So as you know, it's always hard because usually the client that comes to you is the responsible client. You know, they're the person who really is more on top of things and can't stand to see an asset going to waste. And that's a circumstance where they're advancing the costs for the cleaning, or they are the ones constantly proposing a solution that the other party just can take a one message approach to and say no. And that's why partitions end up getting filed so frequently. Okay. I think I've answered all the questions I can find on the chat. If there are more, feel free to email me, and I'm happy to share whatever it is I can with you over what we've experienced in these partition actions before. You know, they are, I think, becoming increasingly common. One of the things you see is because real estate is so expensive here in the Bay Area, it does take multiple investors in order to purchase a property. So you do see co-ownership situations evolve because of just the high cost of living here in the Bay Area. The other thing too is as we see the baby boomers generation, their estate plans come into fruition, then what you see is that their beneficiaries are tasked with sorting this out between themselves, and that too is another reason I think we're seeing a rise in the need for partition actions. So thank you everyone for having coffee with me this morning. I'm amazed that all of you took some time out on a busy morning. Actually, a fair number of you. And I thought because it was summertime, we wouldn't quite see so many participants. These webinars tend to be fairly popular. I hope the materials will be helpful for you. Again, I think I have some supplemental materials as well that I will give to Clayton Dodds in our office. So with that, I'm going to sign off. Thank you.